Welcome to the class video for Module 11, in which we'll be looking at James Madison's Notes on the Convention Debates. There is not much work for us to do in terms of setting up the historical context for this text. We have already talked about the politics of the post-revolutionary period in the 1780s that led to the calling of the Federal Convention in 1787. In this module, we're going to look at James Madison's transcriptions of the debates that occurred within the Federal Convention. And we're going to focus on those debates around theories of representation that led to those two key clauses in Article 1 that we've already looked at in Module 10. That clause that describes how representatives to the House of Representatives will be elected, and that clause that describes how senators get elected or chosen for the Senate. What we want to see in this text is the emergence of this kind of magical Madisonian formula by which these three distinct principles of what do representatives represent. Do they represent people? Do they represent property? Or do they, particularly because this is a federal or national government, appropriately represent the states that are party to this national federation? We're going to see these three distinct principles get sort of confusedly and ambivalently and not very clearly combined into these two houses sandwiched in one branch of government. And that three into two crammed into one is the essential Madisonian formula, or that essentially distinct thing that marks off American constitutional theory from its Aristotelian and European social contract moorings. So that's the big idea for this module. Your assignments, as always, are to do the reading, take the reading quiz, and in terms of working on your textual genealogy, it'll be highly selective whether this reading is relevant to the topic that you're working on, but I want to draw your attention to the document itself. That is, we're reading just a few passages from Madison's notes. It's a giant text that covers literally every single debate that happened every day for the entire 4 months of the convention. So if the selections we are reading for this module are not necessarily relevant to your topic, undoubtedly there is something in Madison's notes that will be relevant. So when you go to the founders.org website and you're looking for sources for your textual genealogy paper, if Madison's notes is among those listed for your clause, I want to draw your attention to how valuable a source it is. As you'll see, it gives you every speaker's point of view. So it's a kind of instant abridged guide, if you will, to seeing diverse points of view on the same topic. So it's an extremely useful source, even if the selections that we're reading for this module are not strictly relevant. Look for it when you get to the founders.org website, because it's a very useful source for the particular project that I've given you. Okay, let's turn now to Madison's notes on the convention. All right. While it is not necessary for us to spend any more time setting up the historical context of the Federal Convention, it is worth spending a moment to emphasize the primary and leading role of James Madison, both as an advocate for the calling of the convention and especially as a kind of parliamentary manager or debate manager in the day-to-day proceedings as the convention met over the summer of 1787. During the Revolutionary War, Madison had served as a delegate in the Virginia State Assembly. When the war concluded, he was elected as a delegate to the Continental Congress, and it was primarily at that time in the early 1780s that Madison developed a close relationship with George Washington. Washington, of course, because he had been commander of the Continental Army, was acutely aware of the weakness of the Articles government. He was in perpetual crisis throughout the Revolution because the Articles government was not able to tax the states, collect the revenue in order to purchase supplies for Washington's army. And he spent most of the Revolutionary War begging and pleading with the delegates to the Continental Congress to give him the arms and ammunition and food and uniforms and supplies and whatnot that the army needed. Washington was not a particularly active or aggressive politician. That was really not his skill set. And in the 1780s, as Madison developed a kind of relationship with Washington, Madison became Washington's spokesperson, if you will. He was the one that was going around trying to gin up support for this idea of revising the Articles of Confederation. Madison was also a kind of archetypal example of those politicians in the post-revolutionary period who were utterly appalled by the radically democratic or populist laws that these new state legislatures were passing, especially those laws designed around debtor relief, the closing of the courts to suits from creditors, the usury laws, the legal tender laws, the stay laws that we discussed in the historical context section of Module 10. We'll see this more clearly in the Publius Essays, where Madison describes the state legislatures of the post-revolutionary period as kind of spinning out of control, right out of the good stage of democracy and rapidly descending into the anarchic stage of the rule of the many. And nothing illustrated this or proved this more clearly to Madison than the assault on the rights of property that he perceived in these debt relief laws. So Madison became convinced that the Articles of Confederation had to be revised and the central government greatly strengthened, not only so the central government could more productively or efficiently meet its obligations, meet the responsibilities that had been assigned to it, but Madison also came to see a stronger national government as an essential counterbalance or counterweight to the radical populism of the state legislatures. And again, we'll see this laid out very clearly when we get to the Publius Essays in the final module of the semester. So using Washington as his kind of figurehead because of Washington's enormous popularity and renown, being the victorious commander of the Revolutionary War, Madison first tried to get a federal convention called in the summer of 1785, which came essentially to nothing. In 1786, he and Washington did get delegations to arrive in Annapolis, Maryland. Only delegations from, I think, 6 or 7 states showed up, and not all of them had official sanction from their state legislatures, so they weren't able to accomplish anything in the summer of 1786 except be able to go back to the Continental Congress and say, we almost got there, can we try it again next summer? And then finally in the summer of 1787, meeting in Philadelphia, they were able to get official delegations appointed from 11 states and unofficial delegation appointed from a 12th state, New York, and Rhode Island has always refused to send a delegation because Rhode Island was utterly opposed to any changes in the Articles of Confederation. Having spent years trying to bring the Federal Convention into existence, Madison was by far the best prepared of all the delegates that arrived in Philadelphia in the summer of 1787. He had spent years corresponding with leaders in different states and had developed intellectual kind of mentoring relationships with people from Connecticut and Massachusetts down to the Carolinas and Georgia. Madison arrived in Philadelphia weeks before the convention was set to meet, specifically to be there to greet the different delegations as they showed up and to kind of massage them and get a sense of where they were. And he was the one that, as the Federal Convention opened at the end of May, who had the clearest plan for how he wanted the debates to proceed and what things he wanted to change. That initial plan that Madison laid before the convention, you may be familiar with as the Virginia Plan. What's important to understand is that the Virginia Plan did not become the Constitution. That is to say, Madison did not get to write the Constitution that he wanted. Much of the Constitution represents compromises on his initial proposals. He would have had, in most instances, a much more nationalistic, a much more powerful central government than the one we ended up with. So he did not get everything that he wanted into the Constitution, but his role or his power over the process was he was the guy that came with a set of proposals, put them on the floor, and then organized the debate around those proposals. So he, if you will, set the terms of the debate. And we'll see some crucial places where he just sort of skipped over questions that would have been fundamental roadblocks, particularly the question of, did the convention have the authority to draft a whole new frame of government, or was it bound by its instructions merely to propose amendments to the Articles of Confederation? And we'll come to that in just a moment. This document that we're reading is a famous document, Madison's Notes on the Debates, and they come from him essentially sitting in the front row every single day that the convention met and acting as a kind of unofficial convention reporter or secretary or transcriber. Each person that got up to speak, Madison wrote just a quick summary of their speech, trying to highlight the major points. And also critically important, Madison recorded every single motion and proposal and the vote on that motion and proposal. So through Madison's notes, we can follow the day-to-day proceedings of the convention. One of the first things that the convention did when it opened its business was pass a motion binding all the delegates to the convention to secrecy. No one was permitted while the convention was meeting, if you will, to write letters to their hometown newspaper back in Boston or in New York or Charleston or Norfolk, sort of spilling the beans on what they were doing. Everybody took an oath of secrecy. All the debates of the convention would be kept private within the convention walls. And so for years, we had no idea what the debates were that produced the final text of the Constitution. Madison took these notes, but he kept them private. He never published them. He left them among his papers when he died, and in his will he ordered that the papers were not to be, or the notes were not to be published until the last delegate who had attended the convention passed away. I believe that was sometime in the mid-1830s. The last delegate died who had attended the convention in 1787. So it wasn't until a couple of generations after the Constitution was ratified that the American public got access to the debates within the convention. So they're an absolutely wonderful resource for understanding the range of points of view that had to get compromised and, if you will, kind of amalgamated together in order to produce the final text of the Constitution. They really illustrate the diversity of kind of intellectual inquiry or philosophical inquiry, if you will, into the range of solutions available to each problem and how the debate sort of rumbled towards, not necessarily logically, not necessarily reaching the most rational conclusion, and we'll see an example of that, but as a kind of uneasy, uncomfortable compromise between strongly held points of view among different factions in the convention. And we'll see that now as we turn to, we're going to pick up with the debates on the nature of representation, and you can see immediately the role of Madison in shaping the debate. So let's turn now to the opening debate around representation. The assigned reading picks up the convention debates on the opening of June 9th, which is roughly the start of the third week of the convention. The first 2 weeks of the convention are devoted to a lot of kind of pomp and ceremony and grand speeches. Then they have to settle in and decide on the rules of procedure and how they're going to conduct debate. And then that second week is largely devoted to Madison laying out a series of proposals through his friend and fellow Virginia delegate Edmund Randolph. So Madison asked Randolph to make these proposals so that he can participate as a debater rather than be responsible for the language that's on the floor, a little parliamentary trick. So let's pick up on the bottom of the left-hand column of page 2. Madison's notes read, "The following resolution, being the second of those proposed by Mr. Randolph, was taken up, to wit, that the rights of suffrage in the national legislature ought to be proportioned to the quotas of contribution or to the number of inhabitants, as the one or the other rule may seem best in different cases. There's a little bit of debate that I've edited out for you, and then Madison himself intervenes to propose this amendment to Randolph's proposal at the top of the right-hand column of 2. Mr. Madison moved, in order to get over the difficulties, the following resolution: that the equality of suffrage established by the Articles of Confederation ought not to prevail in the national legislature, and that an equitable ratio of representation ought to be substituted. All right, so we want to take a moment to pick apart the 3 essential ideas or concepts that are in this proposal. On the one hand, we have the rights of suffrage in the national legislature, or the equality of suffrage established by the Articles of Confederation. That's one thing. And then the question is, should that be replaced by something else? And that something else might be either one of 2 things or some combination thereof: the quotas of contribution or the number of free inhabitants. So we have these 3 things. So first, what are the rights of suffrage in the national legislature, or the equality of suffrage established by the Articles of Confederation? Well, you're perfectly well aware, because you have read the Articles of Confederation, that it permits each state 1 vote. So that 1 vote per state is an equality of suffrage, right? An equality of the right to vote. Madison's proposal, or Randolph's and Madison's proposal, is to get rid of the 1 vote per state rule and to substitute it with something that is more equitable, right? So not equal, but instead equitable. Well, what does equitable mean? Something like fair or just. And what is proposed as a fair or just standard? Either the quotas of contribution or the number of free inhabitants. So what does that mean? The quotas of contribution, as you will recall from having read the Articles of Confederation, although each state gets 1 vote in the Continental Congress, the Continental Congress does not have the power to tax itself. What it does is assign each state its share of the national budget or the national debt. So the Continental Congress says to Virginia, for example, you have 10% of all the people in the country and 15% of all the property in the country. Therefore, your share of our $1 million budget from last year is $200,000. And then the Continental Congress must leave it up to Virginia to go and collect that $200,000 and turn it over to the Continental Congress. That's the quotas of contribution. So you can see why, if you live in Virginia, that may seem inequitable or unfair. We only get 1 vote in the national legislature, but we have to pay for 1/5 or more of the national debt because we're the biggest state with the most property in it. So there is an disproportion or an unfairness between the amount of voting power that a state like Virginia would have in the national legislature versus the amount of taxes that it would be responsible for contributing. So one more equitable standard of representation Madison and Randolph are proposing would be the quotas of contribution. And then the other possible more equitable standard would be according to the number of free inhabitants or population of each state. And that, of course, represents the principle of each person should have an equal voting power in their legislature, whether it be at the state, local, state, or federal level. So we have these 3 standards of representation. Right? Let's turn and look at a quick illustration to try to schematize. In these 2 passages, one from Edmund Randolph and the other from James Madison, these proposals for revising the Articles of Confederation, we see 3 fundamental concepts proposed as the answer to the question, What do representatives represent, especially federal or national representatives? What should representation embody? And there are three possible answers here proposed. One is that representation in the national legislature should represent the states, that the states are the contracting parties to a national federation. And that, of course, is the idea that is embodied in the Articles of Confederation. Why would this be so? Because the states are sovereign bodies. State sovereignty is already established before the creation of national sovereignty. So any subunits within the state, that is people or property or businesses or anything you might think of as existing within a state, are all subsumed in the corporate identity of the state, and it's the state which is the thing, kind of like a corporation, that goes on and acts on their behalf when it comes to national issues. So one fundamental principle, what do representatives represent? They represent states. That leads to the inequities that we just described. So two other ideas that should be immediately cognizable to you to answer the question, what do representatives represent? One thing, of course, they could represent is people, or here numbers, or proportion of free inhabitants, and we'll see other descriptions of this. Where does this idea come from? Well, of course, from John Locke, and remember Tom Paine's description of a natural government. Every individual, no matter how much property they own, whether they're part of one state or another, has a natural right to consent to the laws under which they're governed. So every person has a natural right to be included in representation. So that's another possibility, another possible answer to the question, what do representatives represent? They represent people, and of course this is the answer that we're most accustomed to in our 21st century American civic culture. But there's another answer to the question, what do representatives represent? And that's property, right? Because citizens being represented by a government, the fundamental act that a government can perform over a citizen, the fundamental act of power which a government can exercise over an individual, is the power of taxation, the power to take your property from you. Because remember, Locke said property is your most important natural right that every government should be devoted to preserving. Well, then property gets a special recognition. What should representatives represent? They should represent the right of every individual to resist the power of government to take their property away. Therefore, those people with more property should get more representation. They are more liable to the taxation power of government. So a third answer to the question, what do representatives represent? They represent property. And if you recall the Pennsylvania and the New York Constitutions, if you recall the New York Constitution, not the Pennsylvania Constitution, we see that in the revolutionary state governments in their expression of bicameralism, right? A lower house, which has lower voting requirements, including more people, representing the principle of the people are represented, and an upper house, a Senate, with higher voting qualifications and higher property qualifications to be an office holder, is intended to privilege the rights of property. So at the state level, the revolutionary bicameralism expressed these two principles, that people are represented and property are represented. But of course, the states don't have to wrestle with the problem of subunits being corporate bodies that have their own independent right to consent. That is to say, we don't ask the cities within states to act as corporate bodies consenting to state constitutions, or counties or parishes or any other number of political subunits or administrative subunits of the state. They don't have that same sovereign voice, so there's no conflict between states as contracting agents or the people or property as contracting agents. the amalgamation of these three principles, as we've already noted, into the formula that we find in Article 1, Section 2, Clause 3, and Article 1, Section 3, Clause 1, that describe the election of members of the House of Representatives and the choosing of senators. The formula by which these three concepts get combined into these two bodies of one branch is the magic formula of the Madisonian term. As we proceed reading the text, it's important to have these three concepts in mind, but also to understand that it's really the first concept against the second or the third, that there's this binary between the first and the second or the third as alternate forms of a more equitable ratio. So keep these three concepts in mind, and we'll turn back now to the text and dig into the debate. The primary target, then, of Randolph and Madison's proposals here to start the text is the one state, one vote policy in the Articles of Confederation. That policy, of course, greatly advantages the smaller states that contribute less in taxes to the national budget and disadvantages the larger states that contribute more to the national budget. Because the first two speakers to come out in opposition to these proposals are both delegates from New Jersey, that is David Brearley and then William Patterson, it is conventional to describe the alternative to Madison's plan as the New Jersey plan. And you may have heard in your high school history class or somewhere else that the primary debate within the Federal Convention was between the Virginia plan and the New Jersey plan. The Virginia plan, of course, because Randolph and Madison are from Virginia, and the New Jersey plan, more arbitrarily, as we'll see, it's actually Luther Martin, a delegate from Maryland, who ultimately proposes the resolution, the compromise between the two principles. But because these two delegates are from New Jersey, it becomes conventional then to describe this as the New Jersey plan. But they take very different arguments, or at least alternative arguments, in opposition to Madison's proposal. Brearley begins on the right-hand column of 2. He says he was sorry that any question on this point was brought into view. It had been much agitated in Congress at the time of the forming of the Confederation, and was then rightly settled by allowing to each sovereign state an equal vote. Otherwise, the smaller states must have been destroyed instead of being saved. The substitution of a ratio, he admitted, carried fairness on the face of it, but on a deeper examination was unfair and unjust. So we see that Brearley is really keying in on that phrase, an equitable ratio of representation, in Madison's proposal. That is, what is an equitable? A fair or a just ratio of representation, which infers or strongly implies that the current equality of suffrage is not equitable. So that's got Brearley's hackles up, and he wants to focus on whether the one state, one vote policy is fair or just. He goes through the math and he identifies what the delegates recognize as the three large states, Massachusetts, Pennsylvania, and Virginia, and then correspondingly the 10 small ones. And he claims that those three large states, in a assembly comprised of 90 delegates proportional to each state, those three states would carry a majority. They will carry everything before them. We find out later, of course, that those three states actually would have 42 out of 90 votes, so not quite a majority, but the same principle. It's interesting here that New York is not conventionally considered a large state. It's certainly a borderline. It's much bigger than any of the other so-called small states. So he goes through the math to prove that those three states would be able to force the other 10 states to do their bidding, to carry their will. And 3 being able to overrule 10 is patently unjust, he claims. But he also considers the contrary math at the highlighted passage starting at the bottom of the right-hand column too. Is it fair then, it will be asked, that Georgia should have an equal vote with Virginia? He would not say it was. What remedy then? only that a map of the United States be spread out, that all existing boundaries be erased, and that a partition of the whole be made into 13 equal parts. Now, this is, of course, intended to be absurd, right? He's intending to point out, well, we can't have the kind of justice that you would propose. But notice how this principle that the only way to get true fairness would be to redistribute the existing boundaries of the state so they're all roughly equal in population and property reflects those principles in the state revolutionary constitutions, where they impose a census and require that the people be counted up every 7 years and the districts be redrawn to include roughly the same number of people. That principle of justice is the premise of the debate. Brearley simply is throwing up his hands and saying, well, obviously that's impossible, so the large states will have to live with the only alternative, which is each state gets an equal vote. So he is not so much arguing that population or property are inequitable or unfair ways of doing it. He's simply trying to point out that one state per vote, or one vote per state, is also an equitable way of distributing representation. His fellow delegate from New Jersey, William Patterson, is not so much concerned with arguing the justice of the case. He is going to lay down the law that this is the fundamental condition by which the small states would even consider to go along with any national government, let alone a reform of the Articles of Confederation. Patterson says that he considered the proposition for a proportional representation as striking at the existence of the lesser states. And then the following highlighted passage, that the amendment of the Confederacy was the object of all the laws and commissions on the subject, that the Articles of Confederation were therefore the proper basis of all the proceedings of the Convention. We ought to keep within its limits, or we should be charged by our constituents with usurpation. Now we have to go back to the Articles of Confederation and recall its provisions for amendments in order to understand the significance of Patterson's objection here. If you remember our discussion of the Articles themselves declare that they shall be perpetual, and that any amendments to the Articles require the unanimous consent of all the states. When James Madison and the other advocates for a federal reform argued in the Continental Congress in the 1780s, come on, we got to fix this thing, what they were asking for was each state legislature to send a delegation to propose amendments to the Articles of Confederation within the terms of the Articles of Confederation. That is to say, they would propose amendments that would require unanimous consent by each of the state legislatures. What Patterson is charging here is that Madison and Randolph, through their proposals, aren't simply trying to amend the Confederacy, they're trying to propose a brand new government built from scratch. So Madison is therefore exceeding the legal mandate that they were given by their state legislatures, what they were empowered to do by meeting together as a federal convention. In other words, this convention or this discussion topic is illegal. We're not empowered to consider this question that Madison is proposing. And why is that so? In the next highlighted passage on the left-hand column. The idea of a national government as contradistinguished from a federal one never entered into the mind of any of them, and to the public mind we must accommodate ourselves. Now this language here is a little bit tricky. We have a national government and it's being distinguished from a federal one. That's confusing to us in the 21st century because we call our national government our federal government. So those two terms for us are synonymous. We'll talk about this again when we get to the Federalist Essays. That's really a kind of partisan rhetorical trick of the advocates for the federal Constitution in the ratification process, and we'll talk about that more later. Notice that what Patterson assumes is that a national government is the opposite of a federal one. What can he mean by that? By federal, he's using basically a synonym for confederal or a confederation. A confederation, like the one described in the Articles of Confederation, is merely a league of friendship and alliance, if you remember. That is to say, it's a group of sovereign entities that all come together to cooperate, but don't compromise their sovereignty in doing so, or in other words, a very weak national government that is subordinate to the greater sovereignty of the periphery, the state governments. That is what Patterson means here by a federal one. Right? The opposite of that would be a centralized national government that possesses sovereign powers. So he says the idea of a national government that is a fully sovereign central government as distinct from a federal one, that is where there's weak federal authority or weak central authority and strong state authority, never entered into the mind of any of them. That is, those state legislators who appointed us to come here and to propose amendments to the Articles of Confederation, i.e., Randolph and Madison, you're proposing a radically different form of government. Now, why would that be so? If the states are the primary contracting agents to the central government, then the central government is not empowered to act on the individuals within those states. The taxation authority is the emblematic illustration of that, right? The Continental Congress, the Articles government, is not allowed to tax individuals within the state. They can merely assign to each state its debt, its quota of the national debt, and then ask those states to then proceed to tax the individuals within them. Patterson clearly sees here that by proposing representation based on either population or property, either of those alternative equitable ratios, what Madison's really proposing is that the central government derive its legitimacy, derive its sovereignty directly from the people themselves, not from the people's intermediary, their state corporate bodies. He sees the foundational change in the conception of sovereignty. This point is fundamental, and it's really important that we understand that it's not just about which math is more fair or fairer, and just depends on your perspective which one you like better, but what is underneath this discussion of what does representation represent is what are the sources of authority from which this government we're going to create, where is that source derived, and what limitations therefore would it impose on that government we're creating. Who gets to impose the limitation? Who gets to be umpire? Now, Patterson is going to give a kind of nod to an argument for justice here on the right-hand column of 3. He says, there was no more reason that a great individual state contributing much should have more votes than a small one contributing little, than that a rich individual citizen should have more votes than an indigent one. That, of course, is of the two alternatives for an equitable ratio of representation, either personhood or property. This, of course, is Patterson claiming that principle of personhood, that is, we're all equal, whether we're rich or poor, we should each get a vote, and simply claiming it for the states as a corporate entity. But again, recall that New York State Constitution from the Revolutionary period. The bicameral model among the states allowed those constitutions to concede or to give a concession to each of those principles of representation. That is, one house dedicated to personhood or the people are represented, and the other house dedicated to property being represented. By choosing one of those here for on behalf of the states, he's also implicitly denying the other. Patterson is not so much personally worried about that because his main point is we're not even going to proceed with this discussion if you guys don't give up this proposal in the final highlighted passage. Let them, that is the big states, let them unite if they please, but let them remember that they have no authority to compel the others to unite. That is to say, we small states are just going to walk out of this convention, and you guys are going to be left under the Articles system. There are more of us than you, and we can shut this thing down anytime we like. The drama of Patterson's speech shows why the principles of representation was the foundational conceptual issue in the Constitutional Convention. It was the insoluble question. Only when this issue was resolved could the delegates then proceed to consider the other aspects of the structure of the federal government. If this issue is not resolved, there simply will be no convention result. Now, James Wilson of Pennsylvania is going to give the initial response on behalf of the advocates for a more equitable ratio of representation. And in so doing, he's going to illustrate how difficult a problem this is, because he is simply enunciating what seems like the most basic and a consensus principle of the revolution. He says he hoped that if the Confederacy should be dissolved, that a majority of states would unite for their safety. He entered elaborately into the defense of a proportional representation, stating for his first position that as all authority was derived from the people, equal numbers of people ought to have an equal number of representatives, and different numbers of people, different numbers of representation. What could be more just and fair and commonsensical than that? What could be more consistent with the principles enunciated in Tom Paine's Common Sense, where he described that natural government, that most pure government, where every one of us gets to gather under a tree and cast our vote yes or no for every individual law. Just as there would be different numbers of representations for different numbers of people there, every single person getting an equal vote, why should not this government, as it's being created, also be based on those same principles? And he also could claim a kind of natural rights foundation for his argument, this final highlighted passage on the left-hand column of 4. We've been told that each state being sovereign, all are equal. So each man is naturally a sovereign over himself, and all men are therefore naturally equal. Can he retain this equality when he becomes a member of civil government? He cannot. As little can a sovereign state when it becomes a member of the federal government. We must, as Locke told us, sacrifice our natural rights in order to gain the protections of society. In the same way, countering Patterson's point, that a poor person who joins civil society has to put up with the richer person having more representation in the upper house, so too the small states should put up with the large states having more representation in the national government. Now, of course, you can flip-flop on him in the exact same way we propose for Patterson's, and that exact kind of circularity of that argument is the irresolubility of the conceptual problem. It pits fundamental principles of the revolution against each other. The advocates for the rights of small states like Patterson and Brearley think that they're arguing for that basic principle of the revolution. We're fighting against a strong central government, and we're fighting in behalf of local control. They come to the federal convention and they're advocating for the rights of states against this thing that they see being created that they think of as a new parliament, that thing that we fought the war against. So both sides think that they are grounded in the foundational principles of the American Revolution. We're going to turn now in the next section of the debate that begins on June 11th, and start to see the construction of a solution. But this video is getting a little bit long, so let's stop here, and we'll pick up with June 11th in the next section of the video.